Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You may have been with us all afternoon because it was the last witness in the case against Chad Daybell by the prosecution. The climax was building. We were going to see if the defense case was going to begin, and what happened was a bunch of legal gymnastics to cover up the prosecutorial malpractice that took place. And let me explain. Like I said, prosecution calls their last witness, a special agent with the FBI. They huddle, make sure they have everything correct. The prosecution then rests. The defense makes their motion for judgment of acquittal, and it was kind of a perfunctory motion for judgment of acquittal, although Mr. Pryor says, hey, there are errors in the elemental issues. The judge says, okay, fine. Oh, but wait a second, Mr. and Miss Prosecutor over there, have an issue. You filed your original indictment back in May 25th of 2021, and you said in count 4 that the death of J.J. Vallow took place on September 22nd or September 23rd of 2019. However, when you filed a motion to amend the indictment on February 20th of 2024 that it was granted, you state in that amended indictment, the one that we read to the jury, that Chad Daybell was responsible for the death of J.J. Vallow on September 8th and 9th of 2019. How do we fix this problem? Because Rule 7A says you can amend the indictment up until the moment that you've rested. Oh, and you have rested. So the judge, not sure what to do, but sees that there's an issue, takes 2 hours for the prosecution to come back. They make 3 arguments. First, they say, Judge, this is not a big deal. This is just a clerical error. Don't worry about it. And we filed a motion to amend the original indictment, but we only filed to amend counts 1, 2, 3, and 5, and not count 4, which is an issue here. So even though we filed an amended indictment that we presented to a grand jury, and the grand juror signed it saying that count 4 now has the date of September 8th and 9th of 2019, disregard all that, Judge, because you didn't grant that. So the original count 4 should still exist, even though the amended document says otherwise. And the prosecution says, hey, don't worry about it. The defense isn't prejudiced because they knew these dates were there. So don't worry about it. If not, let us do a variance, Judge, because we have this big date and we'll let the jury decide. Dates don't matter. Precise time and location don't matter. I call BS on that. Yes, time and date does matter. Otherwise, why would they be in every charging document, in every filing across this great land? All right. And then the final one was, hey, Judge, just let us reopen the case. So what does Judge Boyce do in this particular case? The man who's conducted most of this trial in chambers, giving the prosecution everything they want. And let me be clear, I have no love or like for Chad Daybell or Mr. Pryor, but what I do like is the rules being followed. Okay? And the rules need to be applied equally to everyone. If an amended indictment that's filed doesn't mean that it's an amended indictment, then by God, somebody at the prosecution's office that's had 4 years to work on this case should probably figure it out and read something right. That's just the way it is. But they didn't do that. All right? So the judge says, well, I got to look at prejudice and I got to look at due process. And even though 7A says, you can't amend because you've already rested, and the prosecution's had 4 lawyers over there, and we read this to the jury, don't worry, prosecution. I'm going to help you out here because, hey, you're right. You didn't ask to amend count 4, and even though we went to indictment and got an amended indictment, aka superseding indictment, which replaces the indictment, that doesn't matter because you just specifically asked to amend count 4, which, like I said, you don't need it. In any other court in the land, you don't need to supersede on an indictment permission from the court. What the hell goes on in Idaho? I don't know. I don't have time to figure it out because the rules don't matter in Idaho anyway. So the court says, listen, the original indictment had what the prosecution wanted, and obviously they made a mistake, and, mistakes happen, right? I mean, and they've had 4 years to correct it. And, from the time that they filed this in February and we started the trial in May, who could be expected to possibly catch such a thing? And so, yes, count 4 was not amended. Therefore, the defense should have known there's no prejudice. And that was the original count. And oh, by the way, you heard evidence, Mr. Pryor, from the other cases related to those dates. So you knew that those dates, so that evidence from the other case put you on notice if that wasn't sufficient. So clear air, don't worry about it. And I have to balance the rights of fundamental due process against the rights of the state to seek justice. And I find that the rights of the state to seek justice far outweigh any procedural due process rights that one may have to, have the right date on the indictment, on the correct indictment, if that is in fact the indictment, if at all. So don't worry about it. No big deal, no prejudice, no harm, no foul. Therefore, motion for judgment of acquittal as to count 4, along with all the other counts, no big deal. Hey, now the judges say, when we come back next week, when the defense begins their case in chief, we'll try to figure out how do we correct this. Do we just open the file? Do we just do a pen change? And you know what I say? Don't even worry about it. I think you just give them the first indictment, this amended indictment, maybe some jury instructions. Hell, let the jury figure it out, because the prosecutors can't do it. And listen, the prosecutors, this is the problem with the system. When you get judges who always want to help the prosecutors, when they screw it up, fix it for them, they never learn. If this was a defense attorney or a attorney in a civil case and you missed the wrong dates, you would be calling your malpractice carrier right away and saying, oops, we got a problem. But since they're the government, they have no one to report to, nothing bad is going to happen. They look silly for a few minutes, and then they get to say, there was even righteous indignation. Like, we told you we were right, Judge. I don't even know why it was an issue. And you wonder why, even though we were wading through this, I was there live the entire time, talked about it for 2 hours. I said, if you follow the rules, they should grant the motion for judgment of acquittal because no evidence was presented as it relates to the indictment that's filed and read to the jury. But I said, as a defense attorney and someone that's very cynical, that's gotten screwed many a time by the judge over the years, they're going to do legal gymnastics. And what did they do? They did legal gymnastics. Like I said, don't care. I just want the rules followed. I don't care about Chad Daybell. I don't care about his attorney, Mr. Pryor, but I want the rules to mean something. And if the rules don't mean something and the documents that get filed with the court don't mean anything, and you shouldn't be expected to rely upon that, then what the hell are we doing? What the hell are we doing, ladies and gentlemen? And listen, he's going to be found guilty. Let's just cut to the chase. He's going to get found guilty. But if we're not even going to follow the rules, ladies and gentlemen, scary day. I've always said, if we, the people, let the government railroad guilty people, guess what? They're going to do it to innocent people too. And the only people that stand between the government and the defendant, and maybe you someday or your family member, is a little defense attorney saying you can't do that. Constitution requires that I know what the freaking date is and what document is being filed and what I should be relied upon. Bottom line. Sad day for Idaho for sure. I get it. The judge can do his legal gymnastics, but it was the most intellectually dishonest thing I have ever seen. Thanks for watching, ladies and gentlemen. Have a wonderful day. We'll see you next time on Crime Talk.